Start. The position of law which emerges therefore is that for summoning anyone as an additional accused, much stronger evidence is required than mere probability of his complicity. Stop. It also emerges that the test that has to be applied is one which is more than prima facie case as exercised at the time of framing of charge but short of satisfaction to an extent that the evidence, if goes unrebutted, would lead to conviction. Stop. The order under challenge shall have to be tested on the touchstone of the principles laid down by the Honorable Apex Court in Hardeep Singh's case. Stop. The complainant had named 8 persons in his statement, including the present petitioners. Stop. He had stated that the blow on his head with an iron rod was given by petitioner Sombir. Stop. In the final report, the petitioners were excluded by saying that their involvement in the incident was not there and that Sombir was not present at the spot. Stop. No other details were given. Stop. After the framing of charges, the complainant appeared as a witness and reiterated his version and named all 8 persons again. Stop. This time also, he stated that the injuries on his head had been given by Sombir Stow. The fact of accused Pradeep having suffered a disclosure statement that it was he who had given the blow on the head of complainant with an iron rod is not relevant for the time being because these things will be decided at the stage of trial. Stop. Whether the disclosure statement would be admissible in evidence or not shall also be decided at the stage of trial. Stop. It has to be borne in mind that it has repeatedly been held that the statement of an injured witness has to be accorded as a special status. Stop. The question regarding the weight to be attached to the evidence of an injured witness was examined by the Honorable Apex Court in the case of Mukesh and another versus State of NCT of Delhi and others. Stop. After examining the law on the subject, the Honorable Apex Court held that the testimony of the injured witness is accorded a special status in law. Stop. This is as a consequence of the fact that the injury to the witness is an inbuilt guarantee of his presence at the scene of the crime and because the witness will not want to let his actual assailant go unpunished merely to implicate a third party for the commission of the offense. Stop. It was held that the deposition of the injured witness should be relied upon unless there are strong grounds for rejection of his evidence on the basis of major contradictions and discrepancies therein stop. While arriving at this conclusion, the Honorable Supreme Court observed as under stop, we may merely refer to Abdul Said versus State of MP, where this court held as under stop.